McCleskey was born on March 17, 1945. On the morning of May 13, 1978, Warren McCleskey, using his car, picked up Ben Wright, Bernard Dupree and David Burney. All four had planned to rob a jewelry store in Marietta that day. After Ben Wright went into the store to check it out, they decided not to rob it. All four then rode around Marietta looking for another place to rob but couldn't find anything suitable. They drove to Atlanta and decided on the Dixie Furniture store as a target. Each of the four was armed. McCleskey had a .38 caliber Rossi nickel-plated revolver. Ben Wright carried a sawed-off shotgun, and the two others had blue steel pistols. McCleskey parked his car up the street from the furniture store, entered the store, and cased it. After McCleskey returned to the car, the robbery was planned. Executing the plan, McCleskey entered the front of the store, and the other three came through the rear by the loading dock. McCleskey secured the front of the store. The others rounded up the employees in the rear and began to tie them up with tape. All the employees were forced to lie on the floor. The manager was forced at gunpoint to turn over the store receipts, his watch and $6. George Malcolm, an employee, had a pistol taken from him at gunpoint. Before all the employees were tied up, Officer Frank Schlatt, answering a silent alarm, pulled his patrol car up in front of the building. He entered the front door and proceeded approximately 15 feet down the center aisle, where he was shot twice, once in the face and once in the chest. The chest shot glanced off a pocket lighter and lodged in his sofa. That bullet was recovered. The head injuries was fatal. The robbers fled. Sometime later, McCleskey was arrested in Cobb County in connection with another armed robbery. He confessed to the Dixie Furniture store robbery, but denied the shooting. Ballistics showed that Officer Schlatt had been shot by a .38 caliber Rossi revolver. The weapon was never recovered, but it was shown that McCleskey had stolen such a revolver in the robbery of a Red Dot grocery store 2 months earlier. McCleskey admitted the shooting to a co-defendant, and also to a jail inmate in the cell next to his, both of whom testified for the state. Warren McCleskey was convicted of 2 counts of armed robbery and 1 count of murder in the Superior Court of Fulton County, Georgia. McCleskey was African American. His victim was white Atlanta police officer Frank Schlatt. At the sentencing hearing, the jury found 2 aggravating circumstances existed beyond a reasonable doubt. The murder was committed during the course of an armed robbery, and the murder was committed upon a police officer engaged in the performance of his duties. A finding of either aggravating circumstance was sufficient to impose the death penalty. McCleskey did not provide any mitigating circumstances, and the jury recommended the death penalty. The court followed the jury's recommendation and sentenced Warren McCleskey to death. When the Supreme Court upheld the constitutionality of executions in 1976, it held out the promise of punishments determined with fairness and care, under special procedures and guidelines. Death is different, the court recognized, irretrievable even when the state makes mistakes. Further, even the most vengeful citizen comes to realize there's a practical limit to capital punishment. Society would find it hard to execute everyone who is technically eligible. With the amount of killers now on death row, it would take an execution a day for 8 years to clear out the backlog. Warren McCleskey's lawyers proved in his first trip to the Supreme Court, that Georgia courts condemned blacks who killed whites 4 times as often as when the victim was black. Yet the court, by a 5-4 vote, ruled in 1987 that this shameful pattern made no difference. To succeed, an accused must prove that racial prejudice animated his judge, his prosecutor, or his jury. Unable to meet that impossible burden, Warren McCleskey's lawyers proceeded to prove something else, also alarming. Georgia prosecutors had obtained the most damaging evidence against him, his alleged admission that he was the triggerman, from a jailhouse informant who was planted by Atlanta police in violation of Mr. McCleskey's rights. The state hid the informant's status for a decade, stonewalling defense attempts to throw out or discredit his testimony. His lawyers thus spared Warren McCleskey, for the moment. The Supreme Court ruled, 6-3, that they had waited too long to raise the claim, even though they lacked the proof, which the state was hiding, at the time they were supposed to raise it. So once again, Warren McCleskey was again scheduled to go to the electric chair. The only other evidence that Mr. McCleskey had been the gunman came from an accomplice to the robbery. All 4 hold-up men were legally responsible for the killing no matter who pulled the trigger, but Mr. McCleskey was the only one executed, on evidence that was illegally obtained, incomplete and questionable. McCleskey v. Kemp has bearing on claims broader than those involving the death penalty. McCleskey has been used to illustrate that claims based on government denial of equal protection of the laws to racial minorities may fail unless something more than discriminatory effect can be shown. The Supreme Court generally requires, in addition to discriminatory effect, for a discriminatory purpose to be shown as the government's motivation for creating the law in the first place, and Personnel Administrator of Massachusetts v. Feeney, for further clarification of this concept. Thus, although a discriminatory effect may be an ingredient of a successful equal protection claim, it is probably insufficient on its own. Overall, McCleskey may be seen to clarify the Supreme Court's desire to punish discriminatory acts by government rather than merely discriminatory effects. At the same time, federal and state governments choosing to use executions continue to carry out their deadly work with full and undeniable knowledge that the practice is tainted by racial bias. Similar, the pre-Furman practices made unconstitutional in 1972. McCleskey v. Kemp has immunized the criminal justice system from judicial scrutiny for racial bias. It has made it virtually impossible to challenge any aspect, criminal justice process, for racial bias in the absence of proof of intentional discrimination, conscious, deliberate bias. Evidence of conscious intentional bias is almost impossible to come by in the absence of some kind of admission. But the U.S. Supreme has said that the courthouse doors are closed to claims of racial bias in the absence of that kind of evidence, which has really immunized the entire criminal justice system from judicial, and to a large extent public scrutiny, of the severe racial disparities and forms of racial discrimination that go on every day unchecked by our courts and our legal process. The execution of Warren McCleskey by electrocution in Georgia was on September 25, 1991. He was 44 at the time of his execution. Judge Forrester denied the appeal after a hearing ended around 11:20 p.m., but he stayed the execution until 2 o'clock to allow lawyers to appeal it. At 2:17 a.m. Mr. McCleskey was into the electric chair, only to be taken away 3 minutes later when officials learned the High Court was still pondering a stay. He was placed back in the chair at 2:53 a.m. under the assumption that no news from the court meant the execution was still on. Word that the court had denied a stay came just as the execution was ready to begin at 3:04. Mr. McCleskey, who filed repeated appeals over the 13 years between his conviction and his death, and has had a long succession of lawyers, produced 2 landmark rulings in death penalty law. Mr. McCleskey was the 155th person to be executed since the Supreme Court cleared the way in 1976 for states to resume capital punishment. Mr. McCleskey admitted to being one of 4 men involved in a robbery in which Officer Frank Schlatt was killed, but he denied being the one who shot him. None of the other men received the death sentence. Before the execution, he apologized to Officer Schlatt's family for taking part in the attempted robbery, asked his own family not to be bitter about his death, professed his religious beliefs, and decried the use of the death penalty. He neither confessed to being the gunman, nor did he say he was innocent of the killing. I pray that one day this country, supposedly a civilized society, will abolish barbaric acts such as the death penalty, he said. 13 years to say goodbye. Officer Schlatt's daughter said the execution renewed her faith in the justice system. I feel for his family, but he's had 13 years to say goodbye to his family and to make peace with God, said Jody Schlatt-Swanner. I never got to say goodbye to my father. This has nothing to do with vengeance. It has to do with justice. But Mr. McCleskey's supporters, who held demonstrations in Washington, said Mr. McCleskey's case from beginning to end was a potent argument against the death penalty as it is used in the United States. Thank you for watching Death Row. Today's video is sponsored by Noble Titles. Nobility.co.uk is the leading title sellers in the United Kingdom. For more than 25 years they have been selling legal titles. Do not miss the opportunity of a 10% discount on any sale, just by mentioning Death Row.
Here in the UK, there are 2 types of titles. Firstly, there are peerages, which are granted by the Queen. These are not allowed to be sold. Secondly, there are manorial feudal titles. These were once based on land ownership. However, since 1925, titles have been separate from the land itself, with the introduction of the Law of Property Act 1925. Here is the UK government website showing what titles are legal. Manorial feudal titles are regarded as inheritable property, which any nationality worldwide can purchase. Companies selling seated titles or titles with tiny plots of land whilst sounding good are in fact by law novelty souvenirs, not real, genuine titles. Legally approved by UK trading standards, barristers and a UK law lord, no other company has a law lord ruling, 100% legal and proper. You can add your title to passports, bank cards, etc. Even American and Canadian citizens can add the title to their passports on the observation page. All UK and foreign titles have passed 12 legal security checks before offering them for sale. Buy with confidence from the #1 title broker in the world, established 1996. Compliant with Privacy Data Protection Act 2018, the Honours Prevention and Abuses Act and Law of Property Act 1925. All processed through UK solicitors. Strictly private and confidential.